Let me pause that because that's probably too loud. Okay, so let's do, what are we doing here? Where's my sound coming out of? Let's see. Oh, you're on, okay. I'm gonna switch it to my headphones. Uh, I'll tell you guys, what, okay, the way I do this, um, if you're gonna talk and stuff like that, the best thing to do is have headphones on, so that way it isolates the sound. We don't get all that reverberation. That's what happens a lot. Why is this doing this? This is so weird. All right, I'm just gonna pin my video here then. It's just getting weird. Okay. Anyway, all right, how's it going? How's it going today? Breezy.
Good, Joe.
Good, good. So we're probably going to get a bunch of people in here today because I told everyone ahead of time.
That helps.
Yeah, well, I realized that I had the time, so I was able to do it. I was like, yeah, let's do it. But you know what I wanted to do? I wanted to show you guys this court case. Okay, I've covered it on Rumble before, but you know, like there's all this stuff about personal liberties, and you got all the bar attorneys on TikTok telling you that they can tell you what you can and can't do with your private shit, and it's just wrong. It's a lie. They can't govern your private affairs. It's not right. They can't do it because once they violate your personal liberties or that's it. They've lost jurisdiction the second they do that, right? They can govern commerce, and I'm going to show you guys. This is the court case that talks about it, and this is like irrefutable evidence. Hale versus Henkel. So some of you guys probably know about this, but not everybody. But this is the court case we're going to talk about today. Hale versus Henkel. By the way, if you're on TikTok, go to the name of the live is my Telegram link. Go to Telegram, click the Zoom link on there, and you'll be on here, and you can see what I'm sharing. Because I'm not going to share my screen on TikTok. I'm already sharing it on Zoom and on YouTube as well. So if you don't have Zoom, you can go to YouTube and watch us on YouTube. It's just my name, Joe Lustica. Okay, on YouTube. All right, so Hale versus Henkel. This is a case from 2000, 1906. Okay, it was argued January 4 or 5, 1906, and it was decided March 12th, 1906. All right, and it says, under the practice in this country, the examination of witnesses by a federal grand jury need not be preceded by a presentment or formal indictment, but the grand jury may proceed either upon their own knowledge or upon examination of witnesses to inquire whether a crime cognizable by the court has been committed, and if so, they may indict upon such evidence. In summoning witnesses, it is sufficient to appraise them of the names and parties with respect to whom they will be called to testify, without indicating the nature of the charge against them or laying a basis for a formal indictment. Okay, so that's just a setup on like how they're allowed to operate in certain ways, right? Now, the examination of a witness before a grand jury is a proceeding within the meaning of the proviso to the General Appropriation Act of 1903, that no person shall be prosecuted on the account of anything which he may testify in any proceeding under the antitrust law. Antitrust law are that is the law against monopolies. Monopolies are illegal because we live in a free market, right? And we also live in a capitalism. But capitalism and the free market are not the same thing. A lot of people mix these two things up. Capitalism is making income off of income, right? Like stocks, bonds, stuff like that. Like people are using money to create interest and make more money, right? Colloquial term money. Free market is the free trade, selling goods, services like that, or exchanging goods and services for other valuable things. We live in a country of both things, right? So that just people have to understand there is a difference between capitalism and the free market. All right, so the antitrust law is, again, monopolization. That's protecting the free market, okay? Just as a side note, I had an issue with my what do you call it, the utility company, and I actually invoked it's called the Sherman Act, the antitrust laws of the Sherman Act against them. And they were like totally like, hey, whatever we can do to help you, man. Sorry, like, we're sorry we upset you. Let's get on our knees for you. Anything we can do to make you feel better. All right. They really like knew that they screwed up because I could sue them in federal court for antitrust law violation. All right. The word should receive as wide a construction as necessary to protect the witnesses and his disclosures. Okay, that's all talking about proceedings. The dictation of the Fifth Amendment operates only where a witness is asked to incriminate himself. All right, this is important to understand. This is what they're talking about with the Fifth Amendment right to remain silent. You don't have to incriminate yourself, all right? But you can also say something that's incriminating and then, not get in trouble for it under certain circumstances. And it does not apply if the criminality is taken away, okay? So you can open your mouth and talk and incriminate yourself if you're going to get immunity, right? A witness is not excused from testifying before a grand jury under a statute which provides for immunity because he may not be able to, if subsequently indicted, to procure the evidence necessary to maintain his plea. The law takes no account of the practical difficulty which a party may have in procuring his testimony. A witness cannot refuse to testify before a grand jury in face of a federal statute granting immunity from prosecution as to matters sworn to, because the immunity does not extend to prosecutions in a state court. In granting immunity, the only danger to be guarded against is one within the same jurisdiction and under the same sovereignty. The benefits of the Fifth Amendment are exclusively for a witness compelled to testify against himself in a criminal case, and he cannot set them up on behalf of any other person or individual or of a corporation of which he is an officer or employee. Right? But you see,
yeah. And you have to know what you're doing, stand on your square and ask questions when you don't understand. The IRS lady asked for the
are you talking to me right now, or are you just talking to somebody else?
information she was asking for, and she told me that
That's not an answer.
a payment within 9 weeks. But I also know that when you have direct deposit, you probably get it in 3 weeks. So I'm excited.
Are you having a conversation with us?
Week, no matter what's going on, something new.
I'm just going to mute them because they're not answering my question. Okay. A witness who cannot avail himself of the Fifth Amendment as to oral testimony because of a statute granting him immunity, right, from prosecution cannot set it up as against the production of books and papers, as the same statute would equally grant him immunity in respect to matters provided thereby. Okay, so so they're saying here that if you're protected, right, from criminality, then you don't have a Fifth Amendment right. Like, you have to, like, just remain silent. You have to give up the testimony now. All right. But, all right, the search and seizure clause of the Fourth Amendment was not intended to infer with the power of courts to compel the production upon a trial of documentary evidence through a subpoena duces tecum. I don't know how to say that. These Latin phrases get me. All right. While an individual may lawfully refuse to answer incriminating questions unless protected by an immunity statute, a corporation is a creature of the state, and there is a reserved right in the legislator to investigate its contracts and find out whether it has exceeded its powers. Okay, you see what they're saying here? An individual may lawfully refuse to answer, but a corporation is a creature of the state. Okay, corporation. What do they mean? Now look at this. It says there is no clear distinction between an individual and a corporation, and the latter, being a creature of the state, has not the constitutional right to refuse to submit its books and papers for an examination at the suit of the state. And an officer of a corporation which is charged with criminal violation of a statute cannot plead the criminality of the corporation as a refusal to produce its books. Corporations do not have Fifth Amendment rights. What's a United States citizen? It's a corporation. It's an artificial person. What is going on here? I gotta tell you, I'm amazed at how people do not have control over their mics. It just blows my mind, right? I mean, like, I used to teach junior high school, and
Я вас разъебу, блядь, всех уёбки, блядь. Что вы тут устроили, блядь?
okay, see, we got all these fucking child going on here. Well, see all these children? How crazy is this shit? See these fucking children? You see this shit?
Ой, какой большой Кальвина нравится!
Как в лифте пахнет, да не собачьей мочой. Пси-настой, пси-настой, пси-настой. Меня съедят соседи, если вдруг кто-то войдет. Не сыпем пси-настой. Как в лифте пахнет, да не собачьей мочой. Не сыпем пси-настой, пси-настой, пси-настой. Не сыпем соседи, если вдруг кто-то войдет. Не сыпем пси-настой, я люблю чистотой. Когда в лифте пахнет, да не собачьей мочой. Не сыпем
Учи уроки, дебил! Нахуй сюда пришел? Система поиска пидорасов активирована.
Yeah, we got a bunch of childish motherfuckers coming in here, all right, doing that shit. So we're gonna kick them all out right now. So fuck them all. But you see, this is the kind of shit that we gotta do. All right, this is the kind of stuff we're up against because we got a lot of children in here, okay, coming in here acting like that. So I'll tell you what, we just encountered the guy who's pretending to be me, okay, because look what he just did to the live. What was the purpose of doing all that shit, right? To be a complete asshole and disrupt everybody, right? You see, this is the kind of shit we got to deal with, right? But at least we got it all on video now that these people are fucking assholes. They have total disregard. By the way, because we're live and that just happened, I'm going to tell you one thing. First thing is that this is the scammer doing that, okay? There's a guy going around, or a few people going around pretending to be me. I closed the meeting, by the way. So if you really want to get into the meeting, you're going to have to really beg now because I'm not letting anyone else into the meeting because of that shit, okay? So, but this is the kind of crap that we got to deal with, okay? Scammers doing this stuff. I don't do QFS. I don't do, any of this Bitcoin or other cryptocurrency. So if anyone pretending to be me tells you, oh, get your investments, right? Yeah, exactly. He's blocking freedom. Guys, whoever's in here right now, you can unmute and talk. Let's talk about this shit because this is, and you guys are all witnesses. Everyone watching this on YouTube and stuff, you're all witnesses to the level of maturity, right, of the people who oppose us. This is what they do, okay? And this is a great example of the immaturity level of these people. I'm talking about something important. I'm talking about our freedom, our rights. And what do? They start doing all this stuff. Why? Because they don't want people to be free. They want everyone to be slaves and subservient to some other authority, imagined authority. That's what they want. That's what they're looking for. Okay? It's amazing how these people act. Okay? And we're talking like the bar attorney. I wouldn't be surprised if one of these guys was a bar attorney. doing this stuff. I've seen these guys. Yeah, government agent, probably. But you guys see it, all right? This is what we got to deal with. So, anyone else coming in, you're not coming in. That's it.
Hey Joe, how you doing? I've been listening to you for quite a while. Don't let nobody, stop you. Keep on going, keep on doing what you're doing. Just go ahead and keep teaching us what you found out, brother.
Yeah.
Go ahead.
Well, I mean, that was such a disruption, though.
Yeah, it's very ignorant. Just go ahead and do what you got to do. Don't let it get to you. Stop you. Go ahead. Very ignorant.
Yeah, that was nuts. All right, let's go back to our court case now. But yeah, all right. So here we are. All right. Oh yeah, you missed everything. Yeah, you should be on. You should come to Telegram and well, no, go to YouTube now and just go watch the YouTube live. Okay. All right. Look at these fucking guys. Look at this kind of crazy shit they do. This is how they treat people. Like they don't want respect either. But I tell you what, the people who did that shit, they would never do anything like that to my face. Never. I walk down the street, people cross the street just not to pass me on the road because I don't know, people like find me intimidating or something. Right? I'm being serious too. This happened like 3 times this morning just walking here. People like see me and then they cross the street. So, I don't know. All right, franchises, but we're talking about a creature of the state, right? There is no clear distinction between an individual and a corporation. So what are they telling you here? That sentence, they're telling you that an individual and corporation, it's like the same thing, right? And the latter being a creature of the state. So what are they going to do? Oh, you're an individual? Oh, you're a creature of the state because there's no distinction between an individual and a corporation. In fact, let's look at this even deeper. Let's go just a little bit deeper on this here. We're going to go to a W-9 form. That's what we're going to look at real quick. W-9. And check this out. If we look at, let's look at this W-9. We have name of entity / individual. Oh. Business name / disregarded entity. Individual, sole proprietor. What are they telling you there? That this little thing is called a virgil. A virgil is used to show and or, we can show that both mean the same thing. All right. So they're telling you that an individual and a sole proprietor is the same thing. Telling you right here, entity, individual. Right? And they don't see a difference. Okay. So they're not talking about people. All right. An officer or of a corporation. Okay, we already talked about that. All right. Franchises of a corporation chartered by a state are, so far as they involve questions of interstate commerce, exercised in subordination to the power of Congress to regulate such commerce. And while Congress may not have general visitory power over state corporations, its power and vindication of its own laws are the same as if the corporation had been created by an act of Congress. Whoa. You guys see what it's saying here? Okay. So they're exercising subordination to the power of Congress to regulate such commerce. And while Congress may not have general visitorial power over state corporations, its power and vindication of its own laws are the same as if the corporation had been created by an act of Congress. You see what they're telling you? These corporations have the power of Congress. Their corporate bylaws are its power and vindication of its own laws. Are the same as if the corporation be created by an act of Congress. It's crazy. So they're like, oh yeah, we don't know the difference between individual and corporation, but we're going to go ahead and give them the power of Congress, right? A corporation is but an association of individuals with a distinct name and legal entity. And in organizing itself as a collective body, it waives no appropriate constitutional immunities, and although it cannot refuse to produce its books and papers, it is entitled to immunity under the Fourth Amendment against unreasonable searches and seizures. And where an examination of its books is not authorized by an act of Congress, a subpoena ducis tecum, requiring the production of practically all its books and paper, is as indefensible as a search warrant would be if couched in similar terms. Although the subpoena may be too broad in its requisition, where the witnesses have refused to answer any question or produce any books or paper, this objection would not go to the validity of the order committing him for contempt. This was an appeal from a final order circuit court made June 18, 1905, dismissing a writ of habeas corpus and remanding the petitioner Hale to the custody of the marshal. So he was locked up in jail. So now, this is all more stuff just specific to that court case. We're not going to really get into all those little things. But let's look at some of these opinions here. Okay, opinions and dissents. That is all the same thing here. Nope. Okay. All right. Two issues are presented by the record in this case, which are so far distinct as to require separate consideration. They depend upon the applicability of different provisions of the Constitution, and in determining the question of affirmance or reversal should not be confounded. The first of these involves the immunity of the witnesses from oral examination. The second, the legality of his action refusing to produce the documents called for by subpoena. All right, the appellant justifies his action in refusing to answer the questions propounded to him, first upon the grounds that there was no specific charge pending for the grand jury against any particular person. All right, and the answers would tend to incriminate him. So that's what he's saying here, is that one, what was the charge in the first place? The second is he has a right to protect himself from self-incrimination, right? So the first objection requires a definition of the word charge as used in this connection, which is not easy to furnish. And the accused person is usually charged with crime by a complaint made by a committing magistrate, which has fully performed its office where the party is committed or held bail. It's quite unnecessary to find an indictment by a grand jury or by information of a district attorney, which is of no legal value in prosecutions for felonies, or by presentment, usually made, as in this case, for an offense committed in the presence of the jury, or by an indictment, which as often as not is drawn after the grand jury has acted upon the testimony. So that's a big definition for charge, what he's trying to put down there. He's basically saying, like, there has to be a crime, right? And someone has to be bringing the charges, and a magistrate, right, has to say, yeah, we can see that this is a crime that occurred, right? Or an indictment by a grand jury. So there has to be some kind of like substance, like some kind of crime, right, for there to be a charge, right? And that was like what the defendant was saying was that, or the petitioner in this case, he was saying, what was the crime I was being charged with? Where's the crime, right? All right. If another kind of charge can be contemplated, when and by whom must it be preferred? Must it be in writing? And if so, in what form? Or may it be oral? The suggestion of the witness that he should be furnished with a copy of such charge, if applicable to him, is applicable to other witnesses summoned before the grand jury. Indeed, it is a novelty in criminal procedure with which we are wholly unacquainted, and one which might involve a betrayal of the secrets of the grand jury room. Okay. See that? Secrets. They have secrets in there. All right. I think we have to go down quite a bit. What's up? We're gonna find something else. Anyone have any questions, comments while I'm looking for these other parts here? Nothing? Wow, I'm surprised. Sometimes it's hard to find these things. Ah, there we go. Okay, so check this out. This is really interesting. This is not exactly what I was looking for. There's more in here, but we want to look at this. We're going to look at this part of the Constitution here, because this is what they're talking about. Wait, where is it? Okay. All right. The rights of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. No warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Okay, the construction of this amendment was exhaustively considered in the case of Boyd versus United States, which was an information in rem against certain cases of plate glass. Okay, on trial, it became important to show the quantity and value of glass. All right. So we held that a compulsory production of a man's private papers to establish a criminal charge against him or to forfeit his property is within the scope of the Fourth Amendment to the Constitution in all cases in which a search and seizure would be. Okay. So they're saying that they can seize someone's private papers for a criminal charge against him, right? Or forfeit his property. And that's within the scope of the Fourth Amendment. All right, the order in question was unreasonable search and seizure within the amendment. The history of the provision of the Constitution and its connection with former practice of general warrants or writs of assistance were given at length in conclusion with man's own testimony of his private papers to connect him with the crime of forfeiture of his goods is illegal. Okay, so that they're saying that, well, they're saying that you can do that, but they're saying that's actually illegal. You can't actually just forfeit somebody's private shit, right? It's illegal, and the Fourth Amendment says it is. All right. Compelling a man to be a witness against himself within the meaning of Fifth Amendment to the Constitution is the equivalent of a search and seizure, an unreasonable search and seizure within the meaning of the Fourth Amendment. All right. Subsequent cases treat the Fourth and Fifth Amendments as quite distinct, having different histories and performing separate functions. Thus, in the case of Interstate Commerce Commission versus Brimson, right, the constitutionality of the Interstate Commerce Act, so far as it authorized the circuit courts to use their processes in aid of inquiries before the commission, was sustained, the court observing that connection. Okay, so they're allowed to do commerce, right? They're allowed to regulate commerce. Right, it was clearly competent for Congress to that end to investigate the commission with authority to require the attendance and testimony of witnesses in the production of books, paper, tariffs, contracts, agreements, and documents related to any other matter legally committed to that body for investigation. We do not understand that any of these propositions are disputed in this case. Okay, so they're saying that they're allowed to look at these things because of the matter at hand, right? More here though. Corporation creature of the state, it is presumed to be incorporated for the benefit of the public. All right, it receives certain privileges and franchises, which are special rights, and holds them subject to the laws of the state and the limitations of its charter. Its powers are limited by law and can make no contract not authorized by its charter. Its right to act as a corporation only preserved to it so long as it obeys the laws of its creation. Now, this could go for anything. We're not just talking like, like a coffee shop. We could also be talking about a municipality, a courthouse. Okay, these are all corporations. Right? There is a reserved right in the legislature to investigate its contracts and find out whether it has exceeded its powers. It would be a strange anomaly to hold that a state, having chartered a corporation to make use of certain franchises. So that's what the state does. It charters corporations, counties, cities, right? and make use of special rights, special privileges. That's a franchise, right? Could not, in the exercise of its sovereignty, inquire how these franchises have been employed and whether they've been abused, and demand the production of the corporate books and papers for that purpose. The defense amounts to this: that an officer of a corporation which is charged with a criminal violation of the statute may plead the criminality of such corporation as a refusal to produce its books. To state this proposition to answer, while an individual may lawfully refuse to answer incriminating questions unless protected by an immunity statute, it does not follow that a corporation vested with special privileges and franchises may refuse to show its hand when charging abuse of such privileges. So you see, if let's say you, like, this is a really good thing. You can always request the court or the city, right, or even the county, whoever's bringing the charge against you. You can ask them for irrefutable evidence that they're operating as a government and not just as a corporation. All right, let me see your charter. Let me see that you are an actual government and not just a municipality corporation, a municipal corporation doing business as a government. There's a big difference between the two. Okay, so and I'll tell you, I've had some very interesting results. I was helping a family out a few years ago with property taxes. They were getting hounded by the county. They had never paid any property taxes, and they really didn't want to. And we tried a couple of ways to discharge the property taxes, but it wasn't working. So the county was coming down on them really hard. They were getting phone calls every day from the county, like, you better pay, you better pay. And so I just wrote them a little letter, just asking them to prove that they were a, like a de jure government agency and not just a corporation doing business as one. And we never heard back from them ever again. We sent in that letter, and they never called or reached out to them ever again. Now, I can't say that that would work 100% of the time, but in that situation, I think they kind of knew that they were just a corporation doing business, and they couldn't prove that they were a government. I don't think they even had a corporate charter, right? Or articles of incorporation, or something like that, other than whatever that was set up. So it is true that a corporation in this case was chartered under the laws of New Jersey, and that it receives its franchise from the legislature of that state. But such franchises, so far as they involve questions of interstate commerce, must also be exercised in subordination to the power of Congress to regulate such commerce. And in this respect, the general government may also assert a sovereign authority to ascertain whether such franchises have been exercised in a lawful manner, with due regard to its own laws. Being subject to this dual sovereignty, the general government possesses the same right to see that its own laws are respected as the state would have with respect to the special franchises vested in it by the laws of the state. The powers of the general government in this particular in the vindication of its own laws are the same as if the corporation had been created by an act of Congress. It is not intended to imitate, however, that it has a general visitorial power over the state corporations. Okay, so for this reason above, we are in the opinion that an officer of corporation which is charged with a violation of a statute of the state of its creation, that's important. It has to be a statute of the state of its creation, or an act of Congress passed in the exercise of its constitutional powers, cannot refuse to produce the books and papers of such corporation. We do not wish to be understood as holding that a corporation is not entitled to immunity under the Fourth Amendment against unreasonable searches and seizures. A corporation is, after all, but an association of individuals under an assumed name and with a distinct legal entity, okay? In organizing itself as a collective body, it waives no constitutional immunities appropriate to such body. Its property cannot be taken without compensation. It can only be proceeded against by due process of law and is protected under the 14th Amendment against unlawful discrimination. Okay. So even as and this actually comes into play with the assumed name certificate, right? Because if when you're using that assumed name certificate, you're showing that yes, I am using that corporation name. That I'm utilizing it. You're not the one that's liable. You're not the liable party on those, charging instruments anymore, right? What you really are is you're the body aggregate of that corporation. Okay, so they may want the corporation stuff, but not yours. Your stuff is different. All right. Let's see. Okay. So Justin Harlan, all right, says, I concur entirely in what is said in the opinion of the court in reference to the powers and functions of the grand jury. And as to the scope of the Fifth Amendment of the Constitution, I concur also in the affirmation of the judgment, but must withhold my assent to some of the views expressed in the opinion. It seems to me that the witness was not entitled to assert, as a reason for not obeying the order of the court, that the subpoena was infringement of the Fourth Amendment right, which declares, the Fourth Amendment. All right. It may be, I am inclined to think, as a matter of procedure and practice, that the subpoena was too broad and indefinite. Okay, and that's another thing you can use. Think about what he's saying here, right? These are all little things that you can use in a court case, right, to show violations or infringement on your rights. Well, the subpoena was too broad and indefinite, right? They have to specifically say what it is, right? And it says it right here in the Fourth Amendment. The place to be searched or the persons or things to be seized. But the action of the court that were, in that regard was at the utmost only error, and the error did not affect its jurisdiction to make the order, nor authorize the witnesses, whose personal rights, let it be observed, were in no wise involved in the pending inquiry. To refuse compliance with the subpoena upon the ground that it involved an unreasonable search and seizure of the books, papers, and records of the corporation, whose conduct, so far as it related to the Sherman Antitrust Act, was the subject of examination. It was not his privilege to stand between the corporation and the government in the investigation before the grand jury. In my opinion, a corporation, an artificial being, invisible, intangible, and existing only in the contemplation of law, cannot claim the immunity given by the Fourth Amendment, for it is not part of the people within the meaning of that amendment, nor is it embraced by the word persons in the amendment. If a contrary view obtains the power of the government, its representatives, to look into the books, records, and papers of a corporation of its own creation to ascertain whether the corporation has obeyed or is defying the law, will be greatly curtailed, if not destroyed. If a corporation, when its affairs are under examined by a grand jury, proceeding in its work under the court orders complete immunity given by the Fourth Amendment against unreasonable searches and seizures, may not equally rely upon that amendment to protect it even against a statute authorizing or directing the examination by the agency government creating it. Okay, so you see what they're doing here? You see what he's saying here, right? This corporation, right, exists only in contemplation of law. And he doesn't feel that these corporations have immunity. Now, this is a lot of things what they're doing with people today by putting us into this corporate status and then making the rights just disappear. They just, well, you're a person, right? Yeah, well, I mean, he also says that a person and a corporation should not be considered the same thing, right? But he can't stop them from defining person as corporation, right? But he just disagrees with it, right? Which I'm all for that. If we could take out that legal distinction and stop using the word person to define things like trusts, corporations, and all these other like legal entities, and just keep it to human beings, men and women, and just sort that out properly, right? They could just call all these other things corporations and just drop the term person. It would bring some sanity back to the legal system, right? Because he said, he said I was a person, right? Everyone gets crazy about that, No, where is it? Yeah, I'm just going to look for it now. Regulation. Okay. All right. Now this is what I was looking for. Oh, it was all the way down. No wonder I couldn't find it. All right. corporations are in law for civil purposes deemed persons is unquestionable. And the citation from 736 establishes that they are so deemed within the purview of penal statutes. Lord Coke there, in commenting and state of this, respecting the erection of cottages, where the word is used, no person shall, say this extends as well to personal politic, incorporated as natural persons whatsoever. So neither does the fact that a corporation is engaged in interstate commerce in any manner abridge the protection and applicable immunities accorded by those amendments. The corporation of which the petitioner was an officer was chartered by her state, and over its general government has no more control than over an individual citizen of that state. Its power to regulate commerce does not carry with it a right to dispense with the Fourth and Fifth Amendments, to unreasonable search or seize of the papers of an individual corporation engaged in such commerce, deprived of any immunity or protection secured by either amendment. It is true that there is a power of supervision inspecting inside the workings of a corporation, but that belonging to a creature of the corporation. If a state has chartered it, the power is lodged in the state. If the nation, then in the nation, it cannot be exercised by any other authority, as in the nature of the power of visitation. Right? So their power really lays in just regulating commerce. They can't control individual liberties, right? It does say that in here too. I can find it. Let's see. Yeah. English practice which requires criminal investigation can confront the accuser with wisdom, personal liberty. No, that's not the one. Okay, fine. It doesn't say it like that in there, but this is pretty much the case where it talks about these differences between a corporation and a man or a woman, right? You can't, these two things have very different things going on with them. One is that, you know, these corporations as persons assume these rights, okay? But they don't fully get those rights the way like a man or woman would, okay? And that's literally what they're doing with us today, is they're using, you know, those corporate, you know, entities, right? Birth certificate, stuff like that. And what they're doing that is creating this corporate entity, and then they're saying, well, you don't have those rights because you said you're a person. Sneaky. All right, so that's all I was going to show on that one. What else do you guys want to talk about today?
Hey Joe, do you mind talking about the pay your bills again? I did the coupon statement. I have been doing it for a while, but I like how yours is because it's straight to the point, simple, without putting all the codes on there. So I paid my light bill and I did my I think Verizon bill, and I'm waiting to see what happens to see if they're gonna accept it or not. Can you go over that again, if you don't mind?
Yeah, we could do that. I mean, it's real simple. You know, let's go. Don't do it with credit cards. Let's go to billing. Oh, wait. Let's go to Google, and then we'll do billing statement. And we're going to look at one. No, that's not. It says remittance right there. Let's try one more. Let's try utility bill. Okay, cool. There we go. All right, there's one right there. Okay, let's see if we can get a nice big one. Can we? Oh, Nope. What is that? Is it the bottom part? It's right on this. This whole thing is the coupon. All right, payment coupon. Look at that. You even call it a payment coupon on this one. See this? Payment coupon. Please return this portion with your payment and make check payable to City of Savannah. Okay, great. So here's what you're gonna do. Can we make this bigger without? Oh, good. Kinda. All right. Kinda. So here's what we're gonna do. We're just gonna write on here. Payable to City of Savannah. Oh, don't use this color though. I've used blue, black ink. I don't think it matters as long as you don't do like a weird color. All right, because I know some people go, you have to use these colors. Don't. It doesn't matter. Payable to city. You know. All right. Write it all out. Of Savannah, right? I'm just going to save time here. And then they want $116.18. So 100. You're going to write it all out. 116. And you just do the 18/100 dollars. Just make sure you write, oops, that's an O. All right, write that on there just like that. Put the date on there. Was it 5/3/25? All right, make sure you write the date on there. That's important. Okay. It already has a place of payment. Okay, when you look at any check, right in the top left corner, it has like your name and address on there. Well, that's the place of payment on any negotiable instrument, so it's already on there. Okay, you're just adding in the missing pieces to the negotiable instrument. Now you got to sign it, so sign it, right? Without recourse, and that just means that you're no longer liable. Okay, if they tell you we can't take that form of payment, you say, well, you know, that's pretty much it. That's all you got to do, and this will take care of those things. That's how this works. Okay.
Thank you. So you did something with another one where you put pay to the order of, and then you put bearer. I was
Yeah.
trying to research that, and then you put underneath, you said put by, and then your name and signature, and then underneath it, you put a line underneath it, you put your name again, and then agent.
Yeah,
So
you
can
can
you
do that.
explain the bearer?
Bearer is just whoever's holding it gets paid off of that instrument.
Okay.
Like who's ever holding the instrument is getting paid. So it's payable to whoever's holding it. That's the bearer, the one bearing the instrument.
Okay. So I did it like that one, the one you had in the files on Telegram.
Okay.
Is that acceptable to do as well? Would that work?
Yeah. It's not really about. Yes, that's fine. Let me show you. I'll show you where this comes from. Let's go to UCC 3. Well, so the first thing is we're going to look at a few of these things. So the negotiable instrument, right? So it's an order, right? If it's a check, right? So a check is a negotiable instrument. All right. That is paid to the order of or payable to bearer, right? A promise is a note. An instrument is a notice if it's a promise, and a draft if it's an order. So like the Federal Reserve notes are promises, right? A check means a draft, okay? Payable on demand, drawn by a bank. So here's all the components of it, right? Has to be payable to bearer or to order. It's payable on demand, okay? Does not state any other undertaking to be done, right? Undertaking to be of the cower, okay. Protect collateral against secure payment, authorize or power to holder to confess judgment, waiver of benefits. So you can't do any of those things. It wouldn't be on there. Does not state any of those things. Okay. So it just has to have all those requirements on there. The date, right? Time it is issued. That's the date, right? Payable to whoever's holding it or to order. Like people write pay to the order of, and then they write cash on checks. Whoever gets it gets to cash it, right? So anyone can accept that kind of check. If you don't know who to write it out to, or if somebody doesn't want to give their full name or something, you write it out to cash, right? And then they can go and cash it. Issue of instrument. Apply to, okay, maker or drawer. Well, let's do this here. I'm going to show you a couple things. Now, this is what happens when you send these guys a negotiable instrument. They have a duty as a fiduciary, okay? And if they breach their fiduciary duty, you can get them. So when you give this to them, they're the fiduciary. They're an agent, trustee, partner, corporate officer, director, or the representative owing fiduciary duty with respect to an instrument. Okay, representative person means the principal, beneficiary, partnership, corporation, or other person to whom the duty stated in paragraph 1 is owed. So you're the representative person, right? You would be the principal or the beneficiary, representative person. If an instrument is taken from a fiduciary for payment or collection value, the taker has knowledge of the fiduciary status of the fiduciary, and the representative person makes a claim to the instrument or its proceeds on the basis that the transaction of the fiduciary is a breach of fiduciary duty, the following rules apply. So you got to give notice of breach of fiduciary duty, right? By the fiduciary is notice of the claim of the representative person. Okay, so the claim from the representative person gives breach of fiduciary duty notice. In the case of an instrument payable to the representative person or the fiduciary as such, the taker has noticed a breach of fiduciary duty if the instrument is taken in payment, right? Or as a security for debt known by the taker to be personal debt of the fiduciary. So he takes it and then uses it for his own debts. Can't do that. Okay, that's a breach. You know who just did that? Chelsea Clinton just did that, by the way, if you guys knew. But USAID gave her like $83 million, right, for like overseas funds, and she used 13 million of that to buy a wedding and a luxury mansion. Isn't that nice? That's a breach of fiduciary duty right there. But that's like years in jail. You could go to jail for freaking 10, 15 years for that. This is defrauding the government. Okay, taken in a transaction known by the taker to be for the personal benefit of the fiduciary, or deposited into an account other than an account of the fiduciary, such as such, or an account of the representative person. Okay, if an instrument is issued by the representative person or the fiduciary as such, made payable to the fiduciary personally, the taker does not have notice of the breach of fiduciary duty unless the taker knows of the breach of fiduciary duty. So this is really interesting. So you have to know, like when you send these things out to these guys, you have to make the right arguments when they say we don't accept that form of payment. Okay. And then you would just give them notice of breach of fiduciary duty. It said, why attended payment, right? And that falls under these laws here. Tender of payment. If tender of payment, an obligation to pay an instrument, right? Okay, yeah, let's do B. If tender of payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument, and the tender is refused, there is discharge to the extent of the amount of the tender. So if you offer to pay somebody $500 with a coupon, and they refuse it, well, then that's it. That's the $500 just got discharged. But you have to do a notice of breach of fiduciary duty. They have a fiduciary duty, okay? And that's very, very important.
So can you also use the same concept of what is it? UCC, is it UCC 311 where it goes into accord and satisfaction? Get
Yep.
a post
Oh
office
yeah.
money order. I used that with my car, and they said they're waiting basically for me to, for them to get the letter, but I emailed it to them. So I took the money order, and on the face of the instrument, I put accord and satisfaction and a few other things, notice of segregation, and then I put my file number for the UCC that I filed for the vehicle. And I'm just waiting to see what happens. But they did send me a letter yesterday saying they're gonna start performing a repossession on the 8th because I didn't pay them since April 10th, since I sent in that money order. So I've been doing some research and studying, listening to some of your videos and stuff online, trying to get a understanding of how to get them back. But I went to GPT, and GPT was cool and gave me the information, draft me up like 3 letters to send to them, and then another letter if they don't accept it, the notice of demand.
Okay. All right. So let's look at this accord and satisfaction, because you're right. This is where your remedy is.
Okay.
You have the breach of fiduciary duty, and you have accord and satisfaction. Okay. If a person against whom a claim is asserted proves that the person in good faith tendered an instrument to the claimant as full satisfaction of the claim, the amount of the claim was unliquidated or subject to a bona fide dispute, and the claimant obtained payment of the instrument, the following subsections apply. These guys are trying to get back in again. All right. Unless subsection C applies, the claim is discharged. You hear this? The claim is discharged if the person against whom the claim is asserts proves that the instrument or accompanying written communication contained a conspicuous statement to the effect that the instrument was tendered as full satisfaction of the claim. Right? You can hold your own court, though, on this stuff. All right?
So meaning when they tendered it, they accepted it, and after 3 days, it's considered paid off. The vehicle is secured. Okay.
We've done that with the coupons and paid off car loans with the coupons. It does work. They're a little more hesitant about it nowadays, but it has worked in the past. You got to do this. You just got to be able to do, utilize this information correctly with the companies in order to get them to go, okay, fine, you win, you got it. You know what you're doing, because they're crazy. They know that people don't know this stuff, and that they can get away with doing all kinds of crazy stuff to people. Okay. I mean, you already issued them a letter of credit to begin with, so ever since then it's been paid off ever since. All right.
Right.
So now a claim is not discharged if any of these things happen. So pay attention to these 2 things right here, because if any of these 2 things happen, then there is no discharge. And this is probably what a lot of people are mistaking when they do this. The claimant, if an organization proves that within a reasonable time before the tender, the claimant sent a conspicuous statement to the person against whom the claim is asserted, that communications concerning disputed debts, including an instrument tendered as full satisfaction of debt, are to be sent as a designated person, office, place, and the instrument or company communication was not received by that designated person, office, or place. Okay, so that's the first one, right? They have to prove within a reasonable time before the tender that a conspicuous statement, obvious, right? That the communication concerning debts, including instruments tendered as full satisfaction of debt, are to be sent to designated person, and the instrument or company communication was not received. Okay, if it wasn't received, then the claim is not discharged. Okay, but they have to prove that too. Okay, and then the second thing is, if the claimant, whether or not an organization, proves that within 90 days after payment of the instrument, the claimant tendered repayment of the amount of the instrument to that person against who the claim is asserted. This paragraph does not apply if the claimant is an organization that sent the statement complying with paragraph 1I. Okay. So that's this here. Okay. So 90 days after payment of the instrument, claimant tendered repayment of the amount of the instrument to the person against whom the claim is asserted. So if they give you back they have 90 days to give you back the coupon. 90, not 3. They have 90 days to give it back to you. Within that 90 days, if they don't give it back to you within 90 days, then it's discharged.
Okay. So that's 3 months, right?
That's 3 months. But you know, when you're dealing with car repos, they always do it less than 3 months. It's 2 months, right? Or 1 month, right? Like my car got repoed 20 days. It didn't even take a month. I was like, guys, I didn't even have a payment yet. They're like, well, we knew you were going to miss a payment. I'm like, you guys are fucking assholes. Holy shit.
Wow. So they told me April 8th when they sent the letter. So I was told to just go ahead and let's just wait and see when they get the letter with the documents in it. Because I also sent them a revocation affidavit, power of attorney, but I can't really perform like that. I realized after reading. So I'm just gonna wait, and then I got to the 8th, but they again, like you said, they could just come scoop it up now if they wanted to, and break the letter, what they said in the letter. So how would I go about getting it back? I just have to pay the whole balance, or that's old,
Oh, they took
and then
the
take
car?
them to federal court. No, they didn't take it yet. They sent me a letter. I got it yesterday, saying they was gonna get it on the 8th.
That they were going to take it on the 8th?
After I sent this to them April 10th, when I sent them the money order.
I mean, I would probably open up a court case and then file an injunction, so they can't take the car.
Okay.
You know, that's probably the best thing to do. Okay, open up a court case against them. You tendered payment, right? Small claims court, and then do a writ of injunction to stop them from taking the car. Say, look, they can't take the car until we get this dispute settled about, you know, these payments. Okay, that I would think would probably be the best way to stop them from doing the repo without actually just paying them, right? So, if you can get the injunction from the judge, okay, then yeah, you'll be protected. So I would put like a bond in on that case as well, to ensure the injunction. All right, a claim is discharged if the person against whom the claim is asserted proves that within a reasonable time before collection of the instrument was initiated, the claimant or an agent of the claimant having direct responsibility with respect to the disputed obligation knew that the instrument was tendered in full satisfaction of the claim. All right. A claim is discharged if they knew the instrument was tendered in full satisfaction of the claim.
So I did a UCC too. I'm just going to attach the money order and the UCC3. I'm going to attach that in there. And along with the tickets, I had DM'd you too about this, and I emailed you as well. But I'm just gonna, I think I'm gonna have to do what you said, because I think that they're not gonna budge. They changing a lot of things in the system. So,
well, that court case we just went over, it talks about how these corporations have all these rights in the power of Congress, right? So they treat the corporation's bylaws as laws. Okay, look what they've done. Like this is how they've turned the entire country into corporatism. Okay, that's why these guys have so much power and authority. That's why we use the assumed name, because then it gives us that power to act as Congress ourselves. All right, because then we have a corporation. Oh yeah, that's my DBA. I'm doing business, right? I'm gonna let somebody in, but I'm just gonna keep my eye open for them. Let's see. If they start doing crazy stuff, they're out forever, getting banned. Okay, so, but that's it. They have to know that the instrument was tendered in full satisfaction of the claim. Now, there's a couple of ways to do this, okay? If you send an instrument out and you want to know that the instrument was tendered in full satisfaction of the claim, when you mail an instrument, how are you supposed to mail a monetary instrument?
Certified.
No.
Registered mail.
Registered
registered.
mail. Registered mail. You could do a
Registered.
certified mail, but registered mail is really the right way to do it. I have the post office manual, but I have the actual hard copy, not a PDF. Maybe we could find it online or something. Let's see.
When I asked GPT was like, always send it certified. I started to do registered and then get my firm book and put all the information in there and stuff so I can have for my records. But then I was like, well, certified would be a little better too, I guess. So, I mean, I guess you could do it both ways, right?
No, you gotta do a registered mail.
Okay, so send them another letter, registered mail.
Let's see,
Okay.
what page is it on? Registered mail, domestic, 285. Let's go to 285.
And I have a hard time keeping up with the terminology.
No, yeah, I understand. Yeah, it's the red ones. That makes it easier. It's color coded. Green is for just like legal documents. Red is for money, right? Think about all the blood that was shed for people to get like precious stones and metals, money. Registered mail. Okay. Let's zoom in a little bit. Okay. All right. So it says matter which may be registered. Domestic, first, second, and third class matter may be registered. Domestic, fourth class, parcel parter be registered if it is scaled and prepaid with postage at the first class rate of this chapter. Letters and business reply envelopes may be registered without prepayment of postage, but the registry fee surcharge, if any of them. Okay. Let's go. Actually, let's do this. Air metal, unusual value, receipt, endorsement and numbering, post cancellation of stamps, restricted delivery, registered jackets, control. Okay. See, you actually, when you do this, look at this. So here's the first, oh, what did I do? I hit something. I went the wrong way. Okay. Oh, no, that's the wrong button. Okay, it's this one. Look at this. Registry fees and surcharges. The registry fees, which are in addition to the regular postage, and has limits of indemnity, therefore are as follows. So what is this? This is an insurance policy. Okay. That's what this is. So what are you doing? Now, you guys may or may not know this, but the banks insure promissory notes. They insure bills of exchange. So when you send this thing registered mail, you're opening up the door to apply insurance, indemnity, okay?
It's just you. It's just you.
Oh, you're doing this shit again? You guys fucking suck. Go fuck yourself.
So I put 4 or 5.
Piece of shit. All right. Okay. There we go. All right. That's what they do. They come in and disrupt. All right. All right. The minimum registration fee does not provide for indemnification in the event of loss, rifting, rifling, or damage, and is applicable only to the matter having no intrinsic value, such as correspondence notices and the like. Matter having intrinsic value or involving costs of duplication of contents in the event of loss, rifling, or damage requires a registration fee in excess of 30 cents. In excess of 30 cents. Okay, so that's what they're doing here. But once you have the insurance on there, now your thing is covered and it's insured. Are they able to take down a registered insured instrument. They can't do that. Now, there's another way to do this. Like, I know if you're sending out a coupon for like $100-something bill, right? Like let's say $150. You don't want to send a registered mail. It's gonna be like $20-$30, right? Not worth it. But what you can do, right, to ensure payment is to turn it into an obligation of the United States, okay, using a canceled stamp. Here, let's go. Right? Cancel United States stamps. The same thing as Federal Reserve notes, national bank currency, certificates of indebtedness, bonds, fractional notes, certificates of deposit, bills, checks, drafts, money, right? All that stuff. So we utilize the Cancel United States stamp to fund that or protect it. If it's a small bill, like, you could just use like a 3-cent stamp or a penny stamp or something, right? Or a 2-cent stamp, right? And put that on there on the coupons, right? And you can put that on, too bad I erased it. Let's go back. Okay, let's go back to this thing for a second. So where we signed it on the bottom here, you could put a stamp here like this, and then you sign right through the stamp without recourse, right? So it's already been paid now. That would be the only thing I would change on these coupons is put that stamp there and then put your signature there at that part of the stamp, okay? And then sign it without recourse, all right? So that you're showing you paid it. It's a U.S. obligation. They could submit that into Treasury for full payment.
Okay, that I didn't do. I did put the stamp on it, though, like you said. I put the dollar stamp in it on each bill, my Verizon bill and the light bill, but I didn't sign across of it.
Yeah,
I didn't cancel it out.
But that's where I would put the stamp, is on that part right there. All right.
Okay.
Because what you're doing is here. You know what? Let me show you guys something. All right. Let's go. Who likes the Beatles? The Beatles. All right. Everyone likes the Beatles. If you don't like the Beatles, leave.
I got to see him at concert when I was 2 years old.
What? That's awesome. Now, I know we're going to talk about the Beatles because obviously I'm a music fan, but I learned something about the Beatles I learned something about contracts, stamps, and endorsements because of the Beatles. Let's check it out. Look at this. This is really cool. All right. So the Beatles' first contract with manager. Why is this thing stuck? Go away. Okay, there it goes. All right. Look at this. Look at this picture here. Everyone see this picture? All right. Everyone sees that? I hope you guys can see this.
Yeah, I see it. Wow, that is so cool. They did that back then.
Yes. Look at the stamp. How they all signed the stamp, and then you had this guy here sign under it as an underwriter, all right? But that's a revenue stamp right there with their signature. Okay, so when they signed this thing, and then they had an underwriter. Isn't that cool? All right, so this is what they did. Wait, how do I get out of here now? Now I got to stop sharing, figure out how to get out of this thing.
Who was the underwriter? Was it them as the underwriter, or was it someone else?
It was one of their managers.
Oh, okay.
Does it say? I don't know if it says it in here. Come on, Betsy, why didn't you tell us? All right, let's see. All right, let's look at another. Here we go, and here's another shot. Oh, come on. All right, I'll just drag it, put it down. I'm gonna put it up here. Oh, it's too small. Come on. We need a better shot of this thing. But you can see the stamps on here and the signatures. You can't really see it that well. Come on. Let's see if we get some better pictures. Here, this one might be better. Okay, this one looks a lot better. Okay. So you see, now notice this guy, he was like a manager or something. He did not sign over the stamp, okay? But he was still the underwriter, okay? This one signed, and he's the underwriter, okay? Isn't that cool? So these stamps are obligations. And I know someone's going to go say something like, oh, but that's in England. Yeah, where do you think American law comes from? Well, all the people, because I know people say that stuff. They go, oh, but that's in England, man. That doesn't apply here. But all English laws apply in America. Yeah.
Exactly.
Do you think that we just create, like the founding fathers created a whole new legal system magically? No, they just used the English common law. That's why they talk about the writ of habeas corpus. Like, oh, no, we're keeping that one. All right. Is this a better one? Maybe this. I think this is the same one. Anyway, you can see this actually up here is a 10 shilling stamp up here in this this corner here. But they're telling you the purpose of it. Look at this. It's in the top left corner. That's for commerce. Okay, go look at these other things. Look at the notes and these certificates and stuff like that. It's showing you if it's in commerce, if there's a stamp in the left corner, right? That's a seal. 10 shillings. That's a 10 shilling stamp. Okay, I think these are stamps too. I can't tell. It's just too small and I can't make it any bigger. See? The Beatles still providing us with stuff. Isn't that cool? All right.
Yeah. You can screenshot it and then open it up.
No, it came out. I tried that. It came out really bad.
Okay.
Yeah. All right. So.
Thanks, Joe.
Oh, yeah, you're welcome. All right. What else is going on today?
I actually have a couple of questions. One about what we were just talking about, and one about the law you were talking about previous. So I'm in Oklahoma, and I was trying to go through all the Oklahoma versions of the UCC, and if I read it right, it sounds like Oklahoma does not allow you to send them coupons that they send you in the mail back as payment. So
It says that in their own laws.
I'm sorry.
It says that in their laws or their codes.
Yes, if I read it correctly, and I was trying to do my due diligence, I guess, as you say, to figure out how I can utilize this stuff to get to pay this stuff.
Right.
So if that is true, will I have to print up my own instrument? I had got a bill of exchange template and was trying to modify it, and was thinking about sending something like that in with the coupon itself.
What's this debt for?
Well, credit card, loan. I've got or utility bill. Is just anything. This kind of relates to my second question. I was fired. My dad fired me, and it's hard to find a job being a violent felon, and and so now all the bills have fallen on my wife. So I am in desperate search of some way to lower our monthly bills, so that can push off the time. And I also have a mortgage and have lots of equity in the house, so we don't want to lose anything.
Right. Okay, so I see what you're saying there. You can't do the coupons with the credit card companies. They will close your account down. Okay, the utility company is supposed to take the coupons, but they will turn your power off. It's been very difficult dealing with them in that case. Okay.
Yeah, I've got a travel trailer payment that I co-signed for my cousin. He stuck me with, and I've got a personal loan that I had to take out to pay the tag, tax, and title on it that he never paid to stay in good standing, and that's another $300 and almost $400 a month.
In taxes?
Oh no, just in a monthly payment. The loan was for to pay the tag, title, and tax on the travel trailers that he never paid to get everything caught up.
These people, man.
I know it. I tried to help him get a place to stay after his 13-year relationship went bad and he got kicked out with his baby mama, I guess you would say. So instead of
Jeremiah,
him,
you suck too, man. Just so you know. We don't like you. Fuck off. All right, I kicked him out too. They're still doing this shit. What a bunch of fucking pieces of shit.
they ain't got nothing better to do.
No, they don't. They're gonna be here hanging out this entire time. Well, that's good. Now I know where they are. They're definitely in the Telegram group, so we're gonna start kicking tons of people out of Telegram.
Yeah, well, I joined a paid group, and it's some of this. I'm trying to catch up in the trust stuff, and one of the things that I guess somebody said was that some people don't need to know it. So I kind of agree. But anyway, and actually the second question I had was back to the legal stuff. One of the reasons why I'm having such a hard time getting a job is because 20 years ago.
Okay. All right, hold on.
Go ahead.
Well, let's not worry about that. Let's fix the problem.
Okay.
We got it. We don't need to hear the history. Keep that to yourself. It's your private shit. Go on irs.gov. Get the estate EIN, and then go apply for jobs using the estate EIN rather than the Social Security number. Okay. And then what you're also going to do is do a Form 56 and make the estate in charge of the Social Security account. Okay. And the estate will become the fiduciary. Once you do all that, you go apply for jobs, use the estate EIN rather than the Social Security number, and that stuff won't come up on any of your stuff anymore. All right. For entertainment purposes only, of course.
Okay. Well, I was actually I've got a couple of EINs already trying to do that, and I was trying to navigate this stuff before I joined, and I feel like I'm reading a book just at random pages. So it's a 1,000-page book.
Right. Well, forget all the other stuff. Just do that because that's worked for other people. That will work because the estate is the Social Security account. They're the same thing, but there's a difference. It's really funny how this works. All right. Let's go pull something up here. I'll show you guys. All right. Not this. This is nothing. We're gonna go 20 CFR. Was it 301 dash? I think it's 7701 dash something. I forget the number. It's over here though. This is 2. Let's go to part 300. Come on, don't be shy.
When you say estate, is that create a trust and then that becomes the estate, or is there something already there?
I'm going to show you.
Okay.
Okay, so this is 20 CFR 301.7701-11 Social Security number. For purposes of this chapter, Okay, this is Title 26, by the way.
Okay. 6.
The term Social Security number means the taxpayer identification number or identifying number of an individual or estate. Okay, so they're telling you right there, that's it. Okay, that Social Security number is the number of an estate.
Okay.
All right, when you get the estate EIN, this is what happens, and this is what a big thing that people don't understand. Right? Everyone's like, I want to get the Sesticade trust. I want to access the trust. You don't even know what it is. People think it's some kind of mysterious thing or something. It's the Social Security account. But you can't control it as an individual. You're a limited beneficiary under that. Okay? But as an estate, things change a bit because you have a different standing under that estate or over that estate, really. All right. So it says, for the purposes of the chapter of the Social Security, the term Social Security number means the taxpayer identifying number of an individual or estate, which is assigned pursuant to Section 6011B or corresponding provisions of prior law or pursuant to Section 6109, in which the 9 digits are separated by hyphens as follows: 000 hyphen 00 hyphen 0000. Such term does not include a number with a letter as a suffix, which is used to identify an auxiliary beneficiary under the Social Security program. The term account number and Social Security number refer to the same number. See, it's an account.
Okay.
All right. So, like people go, oh, I saw in Treasury Direct, it says that there's no secret account. I said, that's right. There's no secret account. It's not a secret. Does everyone here know that they have a Social Security account? It's not a secret.
Right. Right.
They keep saying there's no secret account. There's no secret account. There is no secret account.
So when you apply for the state EIN, is that the one that, because I have a couple of them, is it like the 99 starting?
No, don't worry about that. See, you're getting into
It doesn't matter?
It doesn't matter. Look, let me show you.
Okay.
Right.
So is there going to be instructions on how to get that in the 26, what you were just?
No, you just apply for regular EIN number,
yeah,
but you're going to use a state.
Yeah, look, here, I'll show you. So you just go to irs.gov. Oops. Okay. irs.gov. Apply for employer EIN number, right?
Okay.
Apply for an EIN.
Yeah, I've done that a couple times.
Oh, it's closed because it's Saturday, but yeah. That's it. That's how you do it. It's not. There's no.
Okay, so in those instructions, there's going to be like an estate option instead of LLC.
Estate, yeah.
Okay.
There's an option for estate. You just click that one. It's really simple.
Okay. Okay.
Okay. Now let me show you what we're talking about here, because people get hung up on these EIN numbers. Okay, and the only suffix numbers that matters is 98, because that just shows that it's foreign. Okay, 98-6 or -7, it's foreign. Okay, look, Social Security number, XXX hyphen XX. See that? And then they do the same thing here with individual taxpayer identification number. They're talking about sole proprietor. This is all sole proprietor. EINs are done this way, okay? Our adoption identifying taxpayer number is done as a Social Security number. Adoption taxpayer identification number is also social, all right? Okay, the first 3 digits indicate the number is temporary. So if it's like a 900 through 999, by the way, if anyone knows anything about these, what are those numbers called? This is how you do them. Okay, anyway, they're going to show you these things in here. So you have your tax class. Here's your code for tax classes. Okay. And you got to read all this stuff. There's so much crap to read. It just never ends. Okay, now, this is the suffix of the EIN. Andover does 14 and 16. Austin does 76, 75, and 20. Okay. See, that campus. This is why I always say campus, because that's their terminology internally. 21 is still Austin. Cincinnati produces 26, 27, 35, and 38. 38 for overflow. So when you're doing it online and it overflows, Cincinnati's online thing will handle the overflows. And then you'll get a 38 number. That means it's an overflow. Okay, but they're also telling you the purpose of what it is for here. All right, Fresno is 80 and 90. Kansas City is 70, 79. Ogden 60. 78 number. So they have very specific uses. We're not going to go into any of that. All right. Look, 88 is overflows. So a lot of people had gotten 88 numbers. Like, I got an 88. I got an 88. It's an overflow number for Ogden. That's all it is. See? This is still Ogden. All right. Overflow numbers. 92 was Ogden. Overflow. 93. I have some 93 numbers, which are primary domestic forms, stuff like that. Legacy stuff. Schedule K1 form 1041. My mic went a little haywire suddenly. All right, sorry about that. What is going on? No, it's my box. I hate when that happens. I got to get a new one. This thing is getting beat up on me here.
Well, I'm sure we're more than willing to deal with it.
Yeah, well, I'm just gonna keep it unplugged for now because it's messing up. All right. Anyway, well, I don't need this here now either. Okay, so now when we get to Philadelphia, there's these two, 30 and 32. Now we will talk about the 98 because it does show up in here. Okay, if we look through, see how they're going to Austin again, Cincinnati, right? I think Cincinnati's doing one of the overflows right now. No, it's not them. Oh yeah, it's Fresno. If you go get an EIN right now, you're going to get a 33 because right now Fresno is handling the overflows.
Yep. Both of the ones I applied for a trust are 33s.
Right. So that was within probably the last like 8 months.
Yeah. Last week.
Yeah. Yeah, exactly. Yeah. So these are the 93s are overflows. So people get all bent out about these things, but I'm telling you, those suffixes don't matter that much. All right. Look, here's another list of them. Right. There's international. 60 and 78 are international. Right. 66 and 98 are international. And that's the Philadelphia campus. Right. So they're telling you right there that, yes, when you get the 98 number, that's foreign. It's international. 60, 78 are international, and 66 is also international. Okay. Those are the international ones. I'm going to what do you guys think? Should I let this guy in? There's somebody sitting here named Chuck. I'll let you guys decide.
I mean, yeah, you can let him in, but if he's starting stupid, just take him off like you did before.
All right.
We don't have time for that. I don't know. People are so ignorant these days.
Just choke slam a bitch, you know what I mean?
Right.
Keep your eye out. All right. Anyway. But yeah. Hi.
Sandra, how are you?
Good. How you doing?
I'm doing good. Just here listening in. I'm just listening to your program.
You learning?
Yes.
Okay. All right. Good. All right. Cool. Any questions, comments? We got about 20 minutes left, and then I got to leave. But yeah, so one thing is, don't worry about the suffix, except if you're doing like a foreign number, then you want the 98 because that's the trust number. They'll only issue that under trust. I think 60 is 66 or something else. I don't know what it's for. All right. We can look in that document locator to go find it, but I'm not going to do that right now. All right. What else we got going on today?
Well, I guess that go ahead.
No, go
Oh,
ahead.
no, sorry. There was a question in the chat. Joseph mentioned something about a Numident record. I'd be interested in that too. I don't know
Oh,
if
the
you knew.
Numident record? Okay, let's go get a Numident record. All right. Let's go get the Numident record. Okay. All right, so this is the POMS. This is the Program's Operations Manual System. This is the internal manual for the Social Security Administration. All right, so the policy for requesting the Numident record under Privacy Act, an individual has a right to access information in our records about him or her, including a copy of Form SS5, right? That's the application for the security card, and the Numident record. A Numident record is a computer extract of the Form SS5 and subsequent applications for replacement Social Security number cards. Okay, so the Numident record is going to have the social, first, middle, last names, full name of birth, other names at first, date of birth, prior date of birth, place of birth, citizenship, race, ethnicity, sex, mother's full name at birth, father's first and last name, date record was established or corrected, control number, date of death. Okay. Now there's two different types. We're going to talk about that here. Yeah, just do a filing and just get all the money back from the property they stole from you. All right. That's for Tony there. Okay. This version is for internal administrative use only and should not be routinely disclosed. So they can disclose it, but not routinely. It contains additional data elements maintained on an individual's enumeration record, e.g. special indicator codes and FICA waiver information. See this for more information regarding the disclosing queries. The Office of Privacy and Disclosure will consider Numident record requests for internal query or requests for additional data elements not listed above on a case-by-case basis. Forward these requests to OPD for processing through Privacy Act Coordinator. Okay, that's the real juicy one. That's the one you really want to get. The external public query, right, is the one that satisfies both first and third party requests for Numident records. It only contains the data elements listed above, as this is a minimum amount of information needed to satisfy a requester's need for Numident record. Okay. Now, this was going to go over more stuff about how to do that. You can write to them, first party, and then you have these steps to do it. They do, how much does it cost? I forget the fees. Okay. You can go click here. More information about the fees we charge is on our website. Okay. We process requests for Numident records on a first come basis. It can take 30 days or longer to process a request. Right, the requester may contact us after 30 days. You can ask them and start bugging them. Okay, you can also call them. All right, there's a phone number. Give them a call. But let's go look at this here. I want to look at this. What's going on in this internal query? Special indicator codes. Does anyone want to know what that is? FICA waiver information. By the way, people who've done the ROE, right? This is going to be in their information, right? A part of their internal query. Because when people have done the ROE, they don't get the taxes taken out of their Social Security checks anymore. All right. So we're going to look at this. All right. We use queries for internal administrative purposes. They should not be routinely disclosed to third parties based on an individual's consent. We also employ a policy of minimizing when disclosing information to third parties, disclosing only minimal information necessary to accomplish the purpose stated in the request. For these reasons, it will be extremely rare that a query may be disclosed in response to a consent request. We should only disclose a query if the individual who is the subject of the record makes a particular request, provides his or her informed consent. Right? So they have to understand the information described in the records, the request for records, ensuring that the consenting individual fully understands the information. Okay. That's all. It doesn't say all that stuff. Okay. An individual consent to disclose a query does not authorize the disclosure of information about other persons in that particular query. We must redact information on other persons on the record prior to disclosure. So like on the SS5, for example, it's going to have your parent's social security number on there. They may redact that, right? If we disclose a query to satisfy a request, we must retain the consent document for a period of 2 years. Or like, for example, if you get the internal query and it shows like a court was, pulling funds in and out of your account, they'll hide certain information about that court, like probably their EIN number, their DUNS number, stuff like that. I mean, no, maybe not the DUNS number, but they will hide certain information about the corporation and what they're utilizing on the back end on that. So that's your Numident record. It's pretty easy to get it, but to get the internal query, which is really the one you want, okay, it's probably going to be a little challenging, okay? What you could do, okay, is give someone power of attorney, have them apply for your record as a third party for you, and get an internal query version of it, and then you just do the same for them. Partner up with someone and do it that way. Do it with someone you trust. Don't do it with some schmuck on the internet that you don't really know, okay? But that's it. That's how you would do that.
Great, thanks, Joe. So this is the kind of thing we could do in the trust group with each other, maybe?
Yes, yeah. If you and another trust member want to do that, because they're probably not going to give it to a first, they probably won't give you the internal query, but they would give it to someone else. So, and the Social Security Administration has those forms for all that stuff anyway.
Okay, awesome, thanks.
Yeah. Oh yeah, but thanks for bringing that up. By the way, I do have a trust community. We have some trust community members in here. They're not the ones that are coming in and being very disruptive. But yeah, anyone want to talk about wait, was anyone in the class that we did on Thursday here right now?
Present and accounted for.
How was the class?
Awesome. I learned at least 10 things I hadn't known before.
Oh, that's awesome.
Yeah, I was in that class too. It was really, I've been studying that stuff for a while, but it tied everything together like by bullet point. It was great.
Awesome.
How do you get in the class?
We have, I have a link. Let's put a link in here.
Yeah, I was up till 3 o'clock, binge watching the stuff, trying to catch up.
I'll be doing
It's
that
pretty
too.
good.
Oh yeah, there's so much stuff. Well, the whole idea of this whole mentorship that I'm doing this month is to get people up to speed on things like what Anthony was saying earlier about like how, he's like reading a book that has no beginning or end, right? It's just kind of like it's all over the place. Everything's all over the place. Well, where do you start? Where's the best place to start? What should you do? Right? And it does depend on your specific circumstance, but also the other issue is where do you really start? And where we want to start is where the beginning of the trap was, right? The trap started really with the Civil War, more so than anything else. The Civil War, because that was the war between the states, okay? And yeah, there will be access to a replay. It's all the lives on YouTube stay up on YouTube forever, unless YouTube decides to ban it, which I haven't seen them do with any of my stuff. So, but the Civil War was really the start of it, because once the states went to war with each other, the federal government decided to come in and assert military dominance over all the states, especially after the Civil War was over, because the Union won. Right? And the Union is the conglomerate of all the states together. Remember, it was a war from the Union versus the Confederacy. People don't realize what the Confederacy actually is, okay? I'm going to show you guys. We're going to look at that right now. So we're going to go, not here, Articles of Confederation, okay? And we're going to look at the Articles of Confederation. They were adopted by the Continental Congress on November 15th, 1777. So it's a year after the Declaration of Independence. This document served as the United States' first constitution. It was in force from March 1st, 1781 until 1789, when the present-day Constitution went into effect. Now, it's still in effect, okay, but it doesn't have the same force as the Constitution, but it's never been repealed, okay? So it's still part of the laws. In fact, it's actually in the statutes at large as statutes at large. So they technically are a part of the laws, all right? Now we're gonna actually look at the, okay. To all to whom these presents shall come, we, the undersigned delegates of the states affixed to our names, send greeting. Whereas the delegates of the United States of America in Congress assembled did on the 15th day of November in the year of our Lord, 1777, and in the second year of the independence of America, agree to certain articles of confederation and perpetual union between the states of New Hampshire, Massachusetts Bay, Rhode Island, and Providence Plantations, Connecticut, New York, New Jersey, Pennsylvania, Delaware, Maryland, Virginia, North Carolina, South Carolina, and Georgia, in the following words, viz. Articles of Confederation and Perpetual Union between the states of New Hampshire, between all the states. Article 1, the style. That's like, you know, that big giant sign when you walk into the gate, it has a giant sign on top. That's a style, okay? It's like, you know, in Jurassic Park, when they walk through the big giant doors, and it says Jurassic Park, that's a style. So the style of this confederacy shall be the United States of America. So right there, they're telling you that the United States of America is a confederacy, okay? So we have a confederacy. So when people go, yeah, not United States, I'm in America. Well, yes, you're part of the confederacy. That's where the republic is, okay? Each state retains its sovereignty, freedom, and independence, every power, jurisdiction, and right, which is not conferred by this confederation, which is not by this federation, especially delegated to the United States in Congress assembled. So you see, they're telling you, United States of America and the United States, they're telling you right there are two different entities. They're not even the same entity. Okay. But here's your right to travel, by the way. This is where it starts. Okay, Article 4 says the better to secure and perpetuate mutual friendship and intercourse among the people of different states in this union, the free inhabitants of each of these states, paupers, vagabonds, fugitives from justice accepted, shall be entitled to all privileges and immunities of free citizens in the several states, and the people of each state shall have free ingress and regress to and from any other state, and shall enjoy therein all the privileges of trade and commerce, subject to the same duties, impositions, and restrictions as inhabitants thereof respectively. Notice they're not talking about residency in here. They're talking about inhabitation, inhabitants, okay? And this is a big, big thing, all right? When you get into the Reconstruction Acts, they make all the state citizens sign an oath that they're a resident and not an inhabitant, right? Because residency has to do with jurisdiction, and habitation does not. One can be an inhabitant on a state, but not be a resident of the state, which means you're standing on the land. Corporate policy doesn't apply to you. It only does if you are a resident, right, or a 14th Amendment citizen, right? And that's the residencies under the 14th Amendment as well. All right. And this provided that such restrictions shall not extend so far as to prevent the removal of property imported to any other state which the owner is an inhabitant. Inhabitant. I like that. I use that in my paperwork with the courts, talking about being an inhabitant. Like, I don't know about this resident thing. I'm not a resident, but I am an inhabitant. You guys make laws for inhabitants? They never answer that question. Oh. All right. But yeah, so they're telling you right here that the United States of America is a confederacy. Now let's look at our Treaty Alliance, Treaty of Paris, Northwest Ordinance, Constitution. Let's go look at the Constitution. All right. Seriously, why can't we just read it? Teach with this document. Wait, you guys don't want us to see the Constitution? Just so weird. Well, it brings that up with the transcripts. How come we don't get the transcripts for that? So weird. All right, fine. We'll do it like this. U.S. Constitution. Same freaking website. I don't get it. Okay. Can't make this stuff up. All right. We, the people of the United States, in order to form a more perfect union, right, do ordain establish the Constitution for the Confederacy. So the United States is a union. The United States of America is a confederacy. The Confederacy lost the war. Now everything's under the United States, right? Right? The victor shall enjoy the spoils of war. So what'd they do? They took over the Confederacy, and all the states have been federalized ever since. So that's why we start there, right? That's the best place to start, because once you understand that, then you can understand the hostile takeover, okay? And that hostile takeover is what we're experiencing today. Okay, then you, of course, you have the bankruptcies and the debts and the getting rid of gold and silver, violating the constitutional provision under Article 1, Section 10, right? Or Article 3, Section 1, right? Clause, well, you know what I'm talking about, the gold and silver one. Article 4. Oh my God, I'm all over the place. Anyway, the point is that once they violate that provision, the full faith of the United States falls onto the people. And we're the ones that become the surety to pay all the debts, right? So now they have ability to tax us, right? To make us use fake currency, right? Rather than real money. And it's just created this whole thing that we're in now. And what do they do with it? They use it to attack us constantly. And now what the courts doing, they're making money off of the bonds, they're making money off of the traffic tickets, right? And then they use things like the cars to violate all your rights under the 4th and 5th Amendment, which is a big problem. Okay, I'm going to show you guys that one. This is the downfall of America. Has a lot to do with the cars. Okay, really, because they use the cars as a way to screw everyone over. We can bypass your rights if you're in a car. It's the automobile exception. This is why I fight about the car stuff so much, because if you can get your rights back, right, in a car, okay, which they have taken away, they've taken our rights away under the cars, okay. So if we can get those back from there, you have them back everywhere. All right, where is it? Automobile exception. Okay, the automobile exception. This is Black Law's 9th edition, by the way. It says the doctrine that when probable cause exists, a law enforcement officer need not obtain a warrant before searching a movable vehicle in which an individual has a lessened expectation of privacy. So you notice, like when cops walk up to the car, they start shining the flashlight in the car, right? They want to see what's in there, because then they can use that as probable cause. Oh, I don't need a warrant. Violating your rights. Well, you don't have, and I mean, yes, the expectation of privacy is less. Tinted windows, they tell you can't block the windows and stuff like that. All right, this is an exception to the 4th Amendment's warrant requirement for search and seizure. Exigent circumstances are presumed to exist. Once the right to conduct a warrantless search arises, the actual search may take place at a later time. They can't even do it right there. They can do that, the warrantless search, but they have to do a warranted search later on for real. Otherwise, the whole thing is total BS. Okay, so they would have to get that, and we can look at exigent circumstances. We'll look at that too. But this is how they ruin the country. This automobile exception is like it's destroying the country because it gets so many people. Like, who here has seen that the cop who went to jail for planting drugs on like 20 different people by searching their car without a warrant? Right? I forget what state it was in. I think it was like either South Carolina or something like that, or Oklahoma. I don't remember. But this is what they do. They use the cars to get everybody, right? They get everyone this way. I know people who, it was South Carolina. Thank you. It was South Carolina. Yeah. So one thing is, never, ever consent to a warrantless search of your car. Oh, we have to search your car. Yeah? Well, okay. All right. What probable cause? Oh, you seem suspicious. No. Never let them get away with that. Oh, you seem suspicious. Is that crime? What's the crime you suspect I have committed? Now, see, this is the thing. Since the state has made every fucking thing you do in a car a crime, right? The cops have a billion reasons to stop you, right? And pull you out of the car and throw you in jail. Because they said, well, you didn't use a blinker. I used a blinker. I didn't see it. I didn't see you use it. So I have probable cause that you're committing crime and searching your car. Right? You see how these guys get so crazy about this shit, right? This is a problem. And if we can fix that, then we would fix a lot of issues in this country. Circumstances. Let's look at this.
The lawyers are a problem too. I was arrested 20 years ago for having a loaded firearm in my car. I'd come out of the grocery store and 3 cops were going through my car.
What?
And the lawyer didn't do anything except get me a plea bargain.
And these guys fucking suck. Do a plea bargain. I'm like,
yeah, easy money for the lawyer.
Yeah, well, there was someone who was on one of my old TikTok account. She came in. They were trying to make her husband do a plea bargain. I said, just do an evidentiary hearing. And then they dropped it when she demanded it. Because they wanted to give him 5 years in jail. And then they're like, well, how about $500 fine? All right, so an exigent circumstance is a situation that demands unusual or immediate action that may allow people to circumvent usual procedures, as when a neighbor breaks through a window of a burning house to save someone inside. Okay. So a situation in which a police officer must take immediate action to effectively make an arrest, search, or seize for which probable cause exists, and thus may do so without first obtaining a warrant. Okay. But there has to be probable cause to exist, right? But in a car, they will use anything as probable cause. Oh, I smell something. Or a smell, right? They'll do that. Or you look a little glazed over or some shit like that, right? They always come up with some bullshit thing. All right. Exigent circumstances may exist, but here's the thing. This is where we're going to limit the cops, okay? If you understand this here, you can limit them. A person's life or safety is threatened. A suspect's imminent escape is imminent, or evidence is about to be removed or destroyed. And that's the questions you ask the cop when he says that he can use exigent circumstances to search your car. You can say, okay, is somebody's life or safety threatened? Yes, mine. How so? I don't have to explain that to you. You absolutely do need to explain it. For the record, how is your safety being threatened right now? Because they tell you get out of the car for officer safety. Yeah, well, what's so dangerous about me sitting in the car? Yeah, a suspect's escape is imminent. or evidence is about to be removed or destroyed. So then you can say, well, do you think I'm going to escape? If you take me out of the car, do you think I would escape then? Well, no. All right. You know, do you think that, you know, like, how am I being, how is your safety or someone's life being threatened? Right? Do you feel that evidence is about to be destroyed or removed? That's it. If he doesn't have that, any of those things, he doesn't have exigent circumstances.
Hey,
Okay.
Joe.
Yeah.
In number 1, it says person. Could that just mean their corporation isn't going to get money?
Well, he can't. If he says that, boy, boy, that's an easy win right there.
But legally, could they make that argument?
Legally, he can. Yeah, he can. Well, no, he can't, because not giving you a ticket does not harm the corporation.
Right, but in a court system where it's based on charges and bonds and is essentially a bank, I don't know, a threat is not getting your money, maybe. I don't know. I'm just, that person thing always jumps out at me ever since you taught us that, so just wonder.
Yeah, no, I think here they're referring to like a man or woman when they say person here, because a life, I don't know. I think they're talking about someone who's alive.
Oh, right, okay. Qualifying term.
Yeah, I know the whole person thing. That's what I'm saying before. It's like the whole thing about person. They should just stop using that for corporations and stuff. There's no such thing as sovereign citizenship. I don't know what you're talking about. This is the kind of stuff that people spread around. What do you think about sovereign citizenship? Sovereign citizenship. Citizenship will require you to submit to the government, right? You're submitting to the dominion of the government through citizenship. And there you go. Cops are sovereign citizens. That's right. Yeah. So sovereign is just one who is in control. Like, we the people are sovereign, right? So we are in control of the government. Or read your state constitution. Tells you. Maybe we could do that again. Let's pick a new state constitution, and we'll see who's really in charge of the state. Is it those lawyers like Hambone over there? I see you there, crybaby. Sovereign body. So pick it. Let's do a state. So let's give me a state, and then we'll look up its constitution. I want to do one I haven't done before.
Have you done Nevada?
Baba?
Nevada.
Oh, Nevada.
Georgia.
Let's do. I think we got Nevada was first, so let's do Nevada. Nah. We'll run through a bunch of them though. Nevada Constitution. So let's see. Okay. Constitution of the State of Nevada. All right. Look, there's no slavery allowed there. Everybody, pack your bags. We're moving to Nevada. By the way, a lot of the stuff that they do is involuntary servitude and slavery. So most of these states do have a provision for slavery being prohibited. But, oh man, they keep saying that over and over again. Slavery prohibited, slavery prohibited. You know what you should do if you're in Nevada and you got a court case? You just type in slavery prohibited. Slavery prohibited. I'm not paying anyone any money against my will. That's slavery. All right. That's funny. Okay, here, let's do, now we got it. All men are by nature free and equal and have certain inalienable rights, among those which are those of enjoying and defending life and liberty, acquiring, possessing, and protecting property, and pursuing, obtaining safety and happiness. All political power is inherent in the people. There you go. Government is instituted for the protection, security, and benefit of the people. You're the beneficiary of this contract. And they have the right to alter or reform the same when the public good may require it. You hear that, Hambone? The almighty state's not so fucking mighty, are they? Okay? It's the people. But the paramount allegiance of every citizen is due to the federal government in the exercise of its all constitutional powers, as the same have been or may be defined by the Supreme Court of the United States. And no power exists in the people of this day or any other state of the federal union to dissolve their connection therewith or perform any act tending to impair, subvert, or restrict the supreme authority of the government of the United States. Holy shit, what are these guys doing here? The Constitution of the United States confers full power on the federal government. Oh, this is wild. The federal government may, by warning the Constitution, employ armed forces in compelling obedience to its authority. Holy shit. These guys were like, you guys have all the power, but we're going to submit everything to the United States. Bow to the masters. All right, let's do another one. What did you say, Kansas? Let's do Kansas. All right, let's go. Bill of Rights. All men are possessed of equal and inalienable rights, among which are life, liberty, and the pursuit of happiness. All political power is inherent in the people, and all free governments are founded on their authority and are instituted for their equal protection and benefit. See? See how they all stay the same? They're pretty similar. Okay. No special privileges or immunity shall ever be granted by the legislator, which may not be altered, revoked, or repealed by the same body. By the way, so if you're in Kansas, okay, here's really funny. And let's say you get in trouble for carrying a gun, right? And you get arrested by the cops for carrying a gun, right? And they say you can't do that. Well, what are they doing? Are they carrying guns? Yeah. You mean I can't do that? But you can? Well, we have special privileges. That's a violation of the Constitution of Kansas. Kansas Constitution says no special privilege or immunity ever be granted by the legislator. Can't have it. Oh, it says in this code right here. Well, guess what? That's unconstitutional according to the Kansas Constitution. All right. So get out of here. Plus, look, it says individual right to bear arms. No slavery, religious liberty, habeas corpus. Okay, what's another state? Let's do one more and then I'm gonna get out of here.
Georgia.
Georgia, okay. Georgia. I'm not gonna try to sing it. Article 1, Bill of Rights. Lieutenant Governor. I'm going to let this guy in here, but if he gets crazy, I'm going to keep my eye on him. So if he gets crazy, I'm kicking him out. All right. Life, liberty, and property. No person shall be deprived life, liberty, property without due process of law. Yeah, let's zoom in on this. A little easier for everyone to see. Okay. Protection to person and property is paramount duty of government and shall be impartial and complete. No person shall be denied the equal protection of the law. Ah, it doesn't have any of that stuff in there, huh? What year is this from? Let's see. 1983. No way. Oh, I see. This is not the whole thing, just a part of it. All right. We, the people of Georgia, relying on the protection and guidance of Almighty God, do and receive this Constitution. Okay. All citizens of the United States resident in this state are hereby declared citizens of this state, and shall be the duty of the General Assembly to enact such laws as will protect them in their full. This is all 14th Amendment shit right here.
Yeah, the crazy thing is about it that they don't apply to the rules. They don't follow their own shit.
Yeah. This is really interesting, though. Wow. They don't have any of those, okay, let's see, right to assemble, right to, well, they don't have it in here, do they? Let's see, people. Let's type in people and see if it comes up. Georgia's Constitution was ratified November 2nd, 1982. No wonder it's a piece of shit. That's it, huh? The right of the people to keep and bear arms shall not be infringed. Well, that's good. The people have the right. Persons don't have rights here, but only people do. All right, so make sure that you're one of the people and not a person. Here we go. They do have it. Look at this. All government of right originates with the people and is founded upon their will only and is instituted solely for the good of the whole. Public officers are the trustees and servants of the people and are all times amendable to them. You live in Georgia? Make sure you shove this in the fucking cop's face. Are you a public officer? Yeah, then you're a trustee and you're breaching your fiduciary obligation. Right? You have an obligation under this trust indenture, right, to protect my rights. So I'm the beneficiary of these rights. This is trust law. They're telling you right here. And you're my servant. I'm one of the people. You do what I tell you to do. Leave me the fuck alone, or whatever you want them to do. Right? Don't scream at them, write them a ticket. I don't know if anyone saw that, but there's this video where this girl's like screaming at the cop, tell to write another cop a ticket. I'm like, I don't know about that. Only a court can judge that? No, they can't. That's bullshit. Anyone can judge anything. Okay? See, he says all this shit as if like the people are not the ones in charge. Right? Only the courts get special privileges, right? Well, it very clearly says that there is no special privileges. So the courts can't make all that shit. Do you have an email so I can reach out to you? Yeah, I have an email. I have the authority too. The court gets its authority from me. All right. All government, our court's government, yeah? Well, then all government of right originates with the people, found upon their will only, as instituted solely for the good of the whole. So that's Hambone again, doing his stupid, the government's more powerful than you bullshit, right? New York State has a constitution. I don't think New York City has a constitution. But unfortunately, that's going to be it for me. I have to get out of here. Yes, and it works. You see, you don't know anything about that because you're I can't say it on TikTok. Yes, but you can impose penalties upon these people and they can pay you, right? Remember the traffic ant? Remember that case? Would you forget about that one? Yeah, he was going to pretend you can't sue the state. You can't sue the city or state. Yes, you can. Retard. Just private message me, all right? If you want my email, I'm not going to just blurt it out on here, but just PM me and then I'll send you my email.
Thanks, Joe. Appreciate you.
Yeah, you're welcome.
Thanks a lot, Joe.
Yeah, what's this? So
Thanks,
the government's more powerful because they have more guns. Well, the whole thing about that was that they weren't supposed to have more, right? And we're actually the posse, the people from age, I think it's 15 up to like 55 or something like that, or the posse, right? There's a whole thing about that. It's in the Federalist Papers too. Anyway, yeah, thanks.
Yeah, it's just a mafia thing.
Yeah, exactly right. It's a mafia thing.
It is. Well, what Elon Musk said, the government is just a corporation with a monopoly on violence.
Yeah.
They kind of are.
Well, Catherine, are you following me on TikTok? Or can someone just share my email? If you got my email on TikTok, just share with her. All right.
I told her to click on your name and then on your profile, and then it shows you the link tree. And
I can't teach people how to use internet apps.
Oh, you're too funny.
No, that's something you gotta do with the person in front of you. You can't do that. Here, I'm just gonna for hate speech. Okay, I got a violation warning on TikTok for hate speech. Fucking Hambone got all, butt hurt.
He's bent over too many times.
No, that's not my email. Yeah, Hambone's, he's just a crybaby. Somebody did. Maybe it wasn't him. Maybe it was someone else. I shouldn't start assuming. It's here. Oh, shit. All right, there's my email. It won't let me pin it, so screenshot it or something. All right. But I'll be honest, if you email me, don't expect to hear back from you right away. No wusses. Yeah, there's so many wusses out there. Like, this is what they've done. They turned America into a bunch of wusses, right? And I'll probably get flagged on TikTok for this, but I don't care. TikTok is a bunch of wusses too. But this is what they've done. They turned everyone into a bunch of wimps and crybabies, and now everything you have to be careful, right? Imagine Andrew Dice Clay trying to freaking go online today and talk. Yeah, the wussification of America. Yeah, for real. What's going on here? Yeah, I mean, this is what's going on. They just
someone in the chat typed Stockholm syndrome.
Yeah. Well, no, he's right. It is Stockholm syndrome. It's so crazy. Yeah. Oh, people are I don't. Thank you, Melody, for talking to people in the freaking YouTube chat. I didn't even see this. I'm gonna add you as a moderator.
You're welcome.
Okay. Save that. Livy's a moderator on there too. Yeah. Oh, yes, that's right. Yes. Oh, so if you click that redivine.com link, right? If you want to do the mentorship, we did the one on Thursday. That was the first class, but you can review it if you sign up for it. Stairway to Sovereignty Mentorship. This is what Bree comes up with. She comes up with these names, like for the classes. She's like, Joe, what are we doing? I'm like, oh, we're gonna do this, and she's like, and she calls it the names and does all this stuff, and okay. I would never thought of that as a name.
She's not your secretary, but she's your girl Friday.
Wait, what? My girl Friday? The 5 monkey experiment?
Yeah, because she's not your secretary, and she says so. But
Yeah.
She is your girl Friday, and the fact that she's the go-to and the planner and the fodder of all the great things.
Oh yeah. She's the marketer. Yeah, that's true. Yeah, because I don't see. Look, I suck at marketing. Look, I barely talk about any of this stuff the whole time. We got this crazy, awesome trust community, right? Which I think is pretty awesome. We just finished a whole book with all the forms. We're showing people how to set up their trusts outside of the United States jurisdiction while remaining in the United States of America, right? And now what we're doing is we're actually creating. I just did a trust for someone, and I was using these equity principles to solidify this trust. Now, what happened is that because of what we did using equity principles, this trust is virtually untouchable. Okay, by any court, maybe in the whole world. I don't know, but they can't even do anything with it. Like, if they saw this trust, they would go, well, shit, we can't even, like, if they made a claim against it, it would automatically be discharged. That's how good this trust I set up is. If someone made a claim against the trust, it's automatically discharged. 100%.
How much you charge to do it?
I charge $1,500 for a trust.
Okay.
But that was some serious, that was like, I was sitting there like, no, we got to do this. By the way, I do have a bond class coming up, like a master class on bonds. And bonding is really like what these governments are doing, these whole agencies. They're doing all this stuff all the time. All their protection comes from bonds, right? Our country runs off of bonds. Look at 18 U.S. Code 8. What's the first one? Bonds is the first one up there, right? It's not, and it's not in alphabetical order. People tried saying that before too. They're like, well, it's in alphabetical order. It's not in alphabetical order, right? It's just the first one. I'll pull it up real quick, but then I really got to go. All right, let's see. So 18 U.S. Code, obligation or other security United States defined. Bonds, it's the first one. Certificates of indebtedness, national bank currency, Federal Reserve notes. See, it's not in alphabetical order. Right? Bills over here. Right? If it was in alphabetical order, it'd be bills and then bonds. Order of importance. Bonds, certificates of indebtedness. Because those are the two biggest things that we're going to find in the country. All of the judges are bonded, except for the ones that aren't, and those are not real judges then. Okay. All these officers are bonded, right? Anyone who took an oath is bonded, technically. And then the certificate of indebtedness is any kind of proof of a debt. Okay. That would be all the promissory notes, mortgages, all that stuff are certificates of indebtedness. And guess where you deposit those? You deposit those into the Social Security account. That's where they get deposited. Okay, you can deposit all these things. They use the bonds. The Social Security account is filled with bonds, special treasury bonds. Okay, certificates of indebtedness. So those are the two biggest types of currency that's actually floating around the country. All right, are those two more than anything else? Then Federal Reserve notes, right? That would be next. I don't think it's national bank currency. Federal Reserve notes. That's the third. But yeah. So that's what's going on. So the whole thing about the bond class is to show you how we utilize bonds for protection, right? For indemnification, right? How we use it to stop, to move liens. There's a lot of stuff you can do with bonds. All right. It's like once you understand how bonds really work, and you can start utilizing them, and anyone can create bonds, by the way. There's no law against that, because I've sent bonds into courts, and if they were like, oh, that's illegal, you think I'd be sitting here talking to you about it? No way, right? So bonds, anyone can make a bond. But also on top of that, bonds do everything. Like all of this functionality within the country happened through bonds, okay? All the debt, right, is backed by bonds. When people talk about Treasury Direct, I mean, it's mostly bonds, and you could do other things like T-bills and stuff like that, but the bonds are really where you want to be at, the Treasury Direct account. Yeah, war bonds, good. Yeah, exactly. So, yeah, a lot of good stuff. The bonds are very, very powerful. How do I utilize a bond for court? Yeah, well, I'm going to be teaching that in the bond class. So the bond class where I will be teaching all that stuff, like how we've used them, how they've worked, yeah. And then, by the way, Livy, in your court case, you can actually, anyway, we'll talk about that. That's a different story, but it's similar. How much? I don't know how much it is. Someone else knows. I don't make the prices for any of these things. I just put the concepts together and put the class together. Bree does all that stuff on the back end.
Just go to the site and see what the prices are.
Yeah.
BreeDivine.com.
Oh, no, that's on TikTok. I don't think they see it. And I can't even share the BreeDivine.com website on TikTok because it blocks it.
Okay, I'll put it up again.
Can you put it in the Telegram group, please? Because I'm not on TikTok.
It's not on. Okay, let's go to Telegram.
The bond class too, if you don't mind. I want to try to get in this stuff.
Yeah, that BreeDivine.com, that's the link. And everything is on there. Anyway, but I gotta be going. I hung out.
One more question, Joe. How many telegrams do you have? Because I want to make sure I'm not in a scam one.
Oh, you might be. If it has my name, that's a scam one. I'm going to show you. So everybody, this is my Freedom Fighters Telegram group. Okay. Someone just did this fucking picture. And whatever this shit is. And then that's the Zoom link from today. And then I have the Freedom Fighter, which has 3,273 subscribers as of now. And the only thing that's posted in here is this stuff. Okay, this is just a channel. So if you just want to stay updated with what I'm putting out, That's what this channel is for. Then there's the group, which everyone could just talk. Okay, just have conversations in here. Everything else is a scam. If it has my name on it, it's not me. And here, look. See, it's Joe wants to chat. How come I can't access the group with my name? Because it's not me.
Oh
Not this
wow,
one. Joe wants to
that's crazy.
This is a dude. Who is this? I know
Oh
this guy.
wow,
He's pretending to be me. That's not me.
that's crazy.
See this shit? This is what they're doing. Yeah, if you're in this thing, Joe wants to chat. Sorry, this group says, how could I be banned from my own group? So it's obviously not mine.
Wait a minute. So freedom fighter, and then I got.
There's a freedom fighter dude. He's fake too. That's not me. Freedom.
Which one is yours? Freedom fighters with an S.
Let's see. That's me. Shit. Now I lost.
Wait a minute. Let me see, because I gotta open it.
If someone messaged you saying that they're freedom fighters, that's not me.
Somebody had probably well, I thought it was you DMing me. I think it was, but you sent me. I was asking for the video that she said that they took down on Rumble about the cops seeing the DOT, and you sent me a link. Was that you? And you said that the link was just restricted.
Yeah. Look. Yeah, that's me.
Okay.
Yeah, that's me. I took the videos down. I had some issues, and so I took those down. And
that's crazy, man.
I may put them back up again one day. I
really want to see that.
Yeah, just Brandon has the video on YouTube. You can just watch. He got it from me. The same process. So just follow his video. I just been getting harassed by the cops for that shit so much. I just couldn't deal with it anymore.
Yeah, that was crazy too. I heard you say that. Dang, that's messed up. Yeah.
Yeah, seriously. I might have to go. And now they're doing it on Facebook too, where there's someone using like an old picture of me, from like 10, 15 years ago, and pretend to be me on Facebook too. So I might have to go get my accounts verified because it's fucking scammers. Yeah, I won't reach out to you asking you to get involved in crypto or QFS or. If you want to get involved, you can get involved, okay, with me. Just email me at jlustica, Lustica, 247 @gmail.com. That's my only email address. I have other ones, but I don't even use them, so that's it. But, guys, I got to go. It was good seeing everybody. Thanks for hanging out. And if you'd like to be part of the trust community, go ahead and click the breeddivine.com link, and you can join the trust community where we talk about all of these other private processes and stuff like that, and trust setups, and utilizing trusts. That's what we're doing in that.
Joe, save the chat.
Save the chat. I think I'll save it. I don't know how that works.
It'll save it to a file on your computer. Zoom chat meeting saved. And then you can see some of the stuff that's really funny in the chat because you get busy between the three, YouTube and TikTok, and that you don't see everything in the chat.
Okay. All right. I'm out. Have a good day, everyone. See you later.